I want to talk a little bit about the main canons of statutory construction used by the California courts. The first one is the constitutional avoidance canon, and it says that statutes will be construed if possible to avoid questions about their constitutionality. The fundamental principle of the constitutional avoidance canon is that a court shouldn't interpret the Constitution only when it is strictly necessary to do so. The rule of lenity, penal code or criminal law statutes whose purpose is to punish offenders must be construed strictly or narrowly in favor of the defendant. The rule of lenity is a canon used in the criminal law. Sometimes it's called the rule of strict construction. And again, it essentially says that an ambiguous statute is to be construed against the state. The rule of the last antecedent is a referential and qualifying phrase. It refers solely to the last antecedent, and it means that any qualifying words are to be applied to the words or phrases immediately preceding the qualifying word or words, and are not interpreted as extending to other words. The serial comma rule, in a series of three items where each is set off by a comma, each item should be viewed as independent of each other. The whole act rule, this says that statutory provisions should be interpreted so that they have a whole coherent meaning. In other words, identical words in the same or related statutes should have the same meaning ascribed to them. The whole act rule is a textual canon that provides that when construing a statute, the text of the entire statutory scheme as a whole is to be considered by the court. The rule against surplusage. Different words in the same statute cannot have the same meaning. In other words, one word is not duplicative or redundant of another word found in the same statute. Adjustum generis. This guides the courts to interpret catch-all phrases, to limit them to the specific words around them. This canon is used generally for interpreting loosely written statutes. It's used if the statute lists certain things and the list ends with a general statement to include other things. Legislative drafters refer to this as the catch-all. Then the court's going to assume that the general statute only includes things that are similar to the items listed. Expressio unius. It says that a list of words with no catch-all means that the inclusion of specific words suggests that the exclusion of other words is to be interpreted. In other words, when a statute includes a list of specific items, that list is presumed to be exclusive, and therefore the statute applies only to the listed items and not to other ones that are not listed here. In pari materia, it's Latin for on the same subject or matter. This is an important doctrine of statutory construction that statutes on the same subject must be construed together. In other words, if a statute's ambiguous, then the court may apply this a canon and look to the rest of the statutory scheme, or perhaps surrounding statutes, in order to determine the meaning of an ambiguous statute. And the final main one is nocitur associus. This says to interpret words or phrases in light of the other words around the statute. In other words, the court should interpret an ambiguous word or phrase by taking into account the words used and the phrases used in their textual context. Nocitur is used for interpreting questionable words that are found in a statute.